Ms Legalista here, aka Attorney Sheila, and we are going back to the Tyre Nichols case. Look, today is May, and I actually have to look at my calendar to see what the date is. Yeah. Today's May 2nd. Yesterday was supposed to be a hearing, but it didn't happen. Why didn't it happen? Well, there's been a protective order issued. There's been a continuance issued. I don't know. Let's go directly to the document so that we can see what's going on with a supposed gag order and a continuance, when any of this stuff is actually going to be back in court, because we were really thinking we were going to be in court yesterday, but that did not happen. So let's see if we can figure out what happened by taking a look at this order granting a continuance. Says here, all right, we've got State of Tennessee versus Demetrius Haley, Emmett Martin, Desmond Mills, Justin Smith, and Tadarius Beans, who are the defendants, if you recall, the police officers who have been charged with second-degree murder, aggravated kidnapping, aggravated assault, oppression. Yeah. This matter came before the court on a motion for extension of time and to reset hearing filed by counsel on behalf of Demetrius Haley. This motion is in response to the motion filed by the Media Coalition, and we're going to find out who this Media Coalition is, since it looks like this is a result of something they filed, which was filed March 17, 2023, after consultation with all parties. And with no objections from any parties, the court finds the motion well taken and grants the motion for extension on behalf of all defendants and resets the May 1st, 2023 hearing. This order hereby eliminates the hearing and all other business regarding this matter and these defendants that was previously set for May 1st. This is why we didn't have a hearing. The hearing on the Media Coalition's motion will now be set for May 19th. So we've got a couple of weeks before we hear that, at 9 a.m. The presence of each of the defendants is waived for this hearing because this really is about the Media Coalition and the court. The May 19th setting will only be used to address Media Coalition's motion, all other business concerning this case, and these defendants will be heard June 5th, at which time defendants will be present. So it looks like we're now going to have to come back June 5th to, I guess, put us back in the spot where we would have been yesterday, May 1st. But what is going on with this Media Coalition? If you guys remember, there was some additional evidence or documents or video that's out there that had not been released. But let's go back and see what the Media Coalition is talking about, because they've now filed their own motion. And this thing is kind of long. They've got all the details in here, though. But let's go ahead and jump right into it and see what this motion is actually about and why the judge felt it was necessary to continue this. Look here, I forgot to turn my phone off again. All right. Here we are. Let's see what we've got here. Media Coalition. This is a motion to intervene and for an order setting an expedited hearing, which is why this is just being heard May 19th, I think we said, granting public access to verbal gag order recording, reducing verbal gag order to writing, and vacating gag orders. So it's like, okay, we want to know everything we can about this gag order, and then we also want to vacate it. All right, by this motion, a coalition of Tennessee and national news organizations and reporters, namely the Associated Press, the Daily Memphian, Memphis Publishing Company doing business as a commercial appeal, MLK 50, Justice Through Journalism, Mark Peresquia, the New York Times Company, WREG TV, Cable News Network, Inc., and this other TV station, WATN TV and WLMT TV. This is collectively called the Media Coalition. So now we know at least who these parties are. All right, let's see what it is they're bringing forth here. It says, by and through undersigned counsel, respectfully move to intervene in the above captioned cases for the limited purpose of seeking an order, 1, setting an expedited hearing on this motion, 2, granting public access to the recording of the court's hearing, presumably on January 26, 2023, because it sounds like they don't really know, at which the media coalition is informed and believes a gag order was issued orally from the bench. 3, reducing any such verbal gag order to writing, so we'll actually know what it is you're talking about. And 4, vacating that verbal gag order. And 5, vacating the gag order on the city of Memphis entered by the court on March 8, 2023, attached as Exhibit A. All right, let's get into this introduction because this is where our background information is. Defendants have been indicted for second-degree murder, aggravated assault, aggravated kidnapping, official misconduct, and official oppression for their part in the death of Tyre Nichols. Body camera footage released to the public by the Memphis Police Department on January 27, 2023, shows defendants kicking and striking Mr. Nichols repeatedly as Mr. Nichols pleads for them to stop. On February 17, 2023, each of the 5 defendants pled not guilty. That was the one hearing that we saw. Journalists, including Jonathan Matisse of the Associated Press, Jessica Jagloy for the New York Times, Jessica Gertler from WREG-TV, and Mark Peresquia, among others, have since submitted public records requests seeking the personnel file of defendant Demetrius Haley from Shelby County, which had previously employed defendant Haley as a correctional officer, Exhibits B and E. The Shelby County Public Records Counsel, Angela Locklear, denied those requests. In one instance, Ms. Locklear initially denied the request pursuant to a criminal court order and stated that the records sought as to Demetrius Haley are not subject to release at this time. Exhibit B. See also Exhibit C. Okay. Ms. Locklear responded to reporter Jessica that the records sought are not subject to release at this time. When Ms. Locklear was asked for a copy of the order, she replied that it was a verbal order from the bench by Judge Jones. And to our knowledge, the court has not entered it into writing. Because that gag order has not been reduced to writing, the media coalition cannot ascertain either the grounds for the order or its scope. So they're basically saying, hey, is this legitimate? Is this gag order legitimate in terms of what they're saying is not to be shared or released yet? And what's the scope of it? What does it cover? Like, we don't even know what it covers because we don't have it in writing. You're just telling us it was an oral order issued from the bench. They are seeking some clarification here. Underside counsel has tried to contact Ms. Locklear, one of the assistant DAs assigned to the case and counsel for defendant Haley, to inquire about the verbal gag order. To date, only the attorney for defendant Haley has responded, and only to state that he could not comment. Yeah, he's like, it's not my order. I didn't issue it. On March 8, 2023, the court entered a second gag order. This one on the city, Exhibit A. The March 8 gag order prohibits the city from releasing videos, audio reports, and personnel files of City of Memphis employees related to this indictment and investigation, to include administrative hearings, records, and related files until such time as the state and the defendants have reviewed this information. Now, remember, I did a video about this one. The March 8 gag order also states that the release of this information shall be subject to further orders of this court and in the public interest will be ordered as soon as practicable. The March 8 gag order is in response to statements by the city on March 7, 2023, that it intended to release additional video, audio, and records related to the city's administrative investigations into Mr. Nichols' death. And, I did a video on this talking about this. So this is out there. This is not any information that's new. Any gag order precluding access to public records pertaining to defendants is not only unwarranted, but also anathema to the First Amendment's protections for news gathering and publication, particularly in the context of criminal proceedings. For centuries, public access to judicial proceedings has been an indispensable attribute of the criminal trial for good reasons. As the Supreme Court has recognized, secrecy breeds distrust in the judiciary and undermines its ability to adjudicate matters fairly and effectively. And public awareness and criticism have even greater importance, whereas here they concern allegations of police corruption. And they're adding in these cases. The role of the press, in particular, in fostering public knowledge and understanding of criminal matters is well established. Indeed, a responsible press has always been regarded as the handmaiden of effective judicial administration, especially in the criminal field. Access to the verbal gag order and vacatur of both gag orders, in this case, is critical to protecting the First Amendment rights, not only of case participants and third parties, but also of the press, who seek to gather news and report on these proceedings and related matters. Without access to the recording of the hearing at which the verbal gag order was entered, it is unclear to whom the gag order applies, what it prohibits, and what facts and law were asserted to support it. Moreover, under Tennessee law, any such gag order must be reduced to writing. Finally, vacatur of both gag orders is necessary because the facts and circumstances here are patently insufficient to support such an extreme measure. They say this measure is extreme. Accordingly, and for the reasons herein, this court should expeditiously grant the media intervenors motion to intervene and enter an order that, one, provides press and public access to the recording of the hearing at which the court entered the verbal gag order, two, reduces it to writing, and three, vacates the gag orders. All right. So now they're going to break all of the legal parts and pieces of this down. But just to sort of give you some background here, what they're saying is, remember, in the very beginning, everything sort of got released, and I've done a lot of videos on that. You had the videos. Remember, you had the chief saying, I'm going to be releasing the videos. There was even a video about the release of the videos. There was all of that. Then there was the decertification process. They provided all of those documents. All those documents are out there online, available for download and for you to look at. So there was all of that information that was available. And I did numerous videos breaking all of these pieces down. Then there was the piece about what happened when, I guess it was Demetrius Haley. I don't want to guess, but I think that's why they're asking about him. Once you have a criminal action come forward like this, people dig into your past. Come on, you guys. We dig into people's past. We Google everyone now. Tell me somebody who you're trying to do business with, who you want to hire, who you're thinking about entering into a relationship with. You have Googled that person. When you have officers put in this sort of position where now there are criminal charges, people want to go back and look and say, well, hey, wait. What else might they have done? And there was this instance out there in the background of one of the officers, and I did a video on that too. So some of this stuff is already out there, and the media coalition is saying, hey, wait, so you put a gag order about the rest of the video and you haven't released that. And now there's this sort of verbal gag order. Like, at least we've seen that. But this, we don't even know who it applies to, what it applies to. And how did you even come up with the fact that there should be this gag order? So the media coalition is like, hey, look, we're media. We want to know. I'm not media. I just want to know too. All right, let's go back here and see if we can sort of break down what their argument is. It says, first of all, the media coalition has standing to intervene. Okay, so remember, this is the state's case against some defendants over here, the 5 officers. So first of all, any and everybody just doesn't get to come in and say, hey, we want to be in the case too. You have to show that you have standing to intervene in the case. All right, under Tennessee law, members of the public, including members of the media, have a right to intervene to oppose gag orders. And we've got the case right there, affirming intervention by media in criminal case to challenge gag order on the press. Okay, so they're giving some background on that. Then it says, similarly, members of the public, including members of the media, have a right to intervene to assert their right to access judicial records and proceedings under the common law and First Amendment. Courts outside of Tennessee likewise have routinely held that members of the press may challenge gag orders that impede constitutionally protected rights to gather and disseminate news. I mean, how else are we supposed to know sometimes? And they go on and on and on here about that. Then they say, there is no doubt that the verbal gag order at issue, whatever its full scope, because they don't know, may be, is impeding the media coalition's ability to gather news because Shelby County has cited the verbal gag order as the basis for denying public records requests for personnel records of one of its former employees, defendant Haley, which would otherwise be available to the public. The same is true. The same is true of the March 8th gag order. The city had announced that it was planning to publicly release materials that appear to be covered by it. In addition, there may be other aspects of the court's verbal gag order that further impede the media coalition's ability to gather news about the former officers accused of Tyre Nichols' murder and related criminal offenses and their prosecution. Local Rule 6.12 also provides any person standing to seek access to court records, and such access here is particularly necessary given that it is only within access to the recording of the hearing at which the court entered its verbal gag order that the public, including the media coalition, can know its scope. As such, the media coalition has standing to intervene to seek the relief sought by this motion. All right. And then they say the court should grant public access to the recording of the entry of the gag order. They've got a local rule there that they're citing. And then they say the court orders must be reduced to writing to be valid and effective. Verbal orders are not binding. And then they go to into their argument for that. I'm not going to read all of that. That's a lot, you guys. And then here's where they get to the part where they say the gag orders should be vacated. Gag orders in criminal cases implicate weighty First Amendment interests and accordingly may be imposed only in rare, extraordinary circumstances. And they're probably asserting that this is not an extraordinary circumstance. Then they say the gag orders on third parties like the city and Shelby should be vacated. Let's see what else they're saying here. We already know all of that. And they're citing a number of cases here. It's restricting trial participants from publicly discussing the cases. There is not a substantial likelihood that defendants' fair trial rights would be prejudiced absent a gag order applicable to trial participants. So they've gone through and put in, I guess, just about everything they need to put in order to make their case that, hey, this is just not working here. Reasonable alternative measures. This is a pretty good presentation of their argument. Any gag order on trial participants must be narrowly drawn. In this case, is verbal. So I don't even know how you determine whether or not it's narrowly drawn or not. How would you know if it's just verbal? All right. It says, as discussed above, the facts do not justify any gag order here, but even if a gag order was warranted, it must be narrowly tailored in the manner described in Carruthers, which was a case. The Media Coalition respectfully requests that the court set an expedited hearing for this motion, provide them with access to the recording of the entry of the verbal gag order in these cases, reduce the verbal gag order to writing, and lift the court's gag orders in their entirety. Yeah, and so this was dated March 17, 2023. The Reporters Committee for Freedom of the Press, Counsel for the Media Coalition, and then you have service there for each of the attorneys representing, let me go back, for each of the attorneys representing the defendants. And so Michael Stingle is the one who's representing Demetrius Haley. And then let's see if okay, so we don't have the exhibits here in this one. It would have been nice that wherever I got this from, if they had included those exhibits to make things easier for us. But now we have a better understanding of what is going on, why there was no hearing on May 1st. And it was because, hey, this media coalition sort of jumped into the case and said, we can't even get the information that we need because we've been told that there's a verbal gag order. And so can you please clarify? Because first of all, we don't know if there's an order. So can we get the hearing recording that talks about it? And you don't have it in writing. You need to put it in writing. And finally, we don't even think that you should have this gag order. We think that needs to be vacated. So that's where we stand. That's why there was no hearing. That's why it got pushed off to June. And that's why we're going to be back in court in a couple weeks to see what the court says about this gag order. So I hope that brings you up to speed now with all of the details concerning why there was no hearing on May 1st. And when the next hearing is going to be. Go ahead and give the video a thumbs up and don't forget to subscribe. Peace.